Welcome to our third lecture covering religious discrimination in the workplace. Let's advance to the end of the presentation, slide 81, and begin from that point. As you know, we've already discussed the definition of religion. We've talked about the prima facie case that needs to be made when the person is alleging good old-fashioned just discrimination, as well as when the person is alleging failure to reasonably accommodate. Then we've talked about the duty to reasonably accommodate and its limit, its upper limit, which is when it becomes an undue hardship, something that the employer is not required, but certainly can do. We have three remaining topics to cover. The first that we're going to be covering today is religious proselytizing and the topic of harassment, which is related sometimes. There's lots of different ways a person can be harassed from a religious standpoint, but one can be through the process of proselytizing. And then finally we have, or not finally, but next we have the union, how the union interacts. I'm not going to do a very deep dive into this topic because it's relatively unusual to find unionized facilities in Texas, but it's certainly possible to have those, and certainly if a person were to move to a different part of the country, the involvement of unions in the workplace becomes sometimes significantly more prevalent. And finally, we'll discuss the topic of religious organizations. Again, we're not going to do a deep dive here. It's relatively unusual for HR professionals to be working in religious organizations or for paralegals or attorneys to be working in those types of environments. But certainly that can arise, and so it's helpful to know what the ins and outs of the rules are regarding those topics. So let's begin. Just like with race discrimination and sex discrimination and national origin and color and age and disability, within those categories of discrimination, there is a subcategory, and that is the category of harassment. Harassment is a type of discrimination, and we see that also in the framework of religious discrimination, that this is a particular category. And the same things that we saw when we talked about race and national origin harassment, we see in religious harassment. Many times these are jokes. There certainly have been cases where people have been beat up because of their religion and frightened and certainly treated in very, very bad ways. And so this is not a theoretical issue, but a real issue that sometimes employees confront or face. So examples might be when a particular stereotype, a hurtful stereotype, is applied to people of a particular religious group, even though perhaps that stereotype applies to only a few or perhaps none of the members of that group. So here are some examples that some people have unfairly and illegally attributed. Things like Muslims are all terrorists, Jews are all cheat, Mormons are polygamous, a mocking imitation of charismatic Christians speaking in tongues, saying things like all, whatever the religion is, are going to an unpleasant place, or people who believe that are stupid, or whatever the thing might be. All of that is obviously tremendously inappropriate for the workplace, very detrimental, and can raise the specter of a religious harassment case. Let's consider, though, for a second the special case, the proselytizing case, because this is especially interesting, and it's an area of the law that really just applies to the religious discrimination / harassment characteristics. So since it's unique to this topic, we're going to do a bit deeper dive into that. So imagine that you have employee A, we'll call him Bob, and part of Bob's religion is the belief that one has to share Bob's theology or share Bob's religious activities or whatever the bundle of things are in order to go to heaven or maybe to avoid hell. And so, because Bob is genuinely concerned about the well-being of his colleagues, he doesn't want his colleagues to go to hell. He wants his colleagues to go to heaven. Plus, he may have a religious requirement that he attempt to convert. After all, if people were on a sinking ship you would feel an obligation to rescue people from the sinking ship. Well, that's the same idea that Bob has in the workplace. He feels that it is important both for his own soul that he assist or help or try to persuade these individuals to convert to his religion, and he also thinks it is absolutely a requirement for their souls that this happen. So that's Bob's perspective. Mary's also in the working environment, and Mary doesn't share Bob's particular religious perspective. She isn't a member of his religious group. Perhaps she's an atheist or agnostic, or perhaps she's happily involved in a different religious tradition. Bob thinks she's going to hell. Mary doesn't agree. Mary doesn't particularly like to hear Bob's theology being advanced. She doesn't agree with it. She doesn't like it. She's not comfortable with it. Bob feels a religious obligation to share. Mary feels harassed by this attempt at proselytizing or converting her. So now you have two competing individuals. Both feel that they should be protected from the other in some sense. Bob, or not, I guess Bob doesn't feel like he needs to be protected, but Bob feels he needs to do these tasks as part of his religious obligation, and Mary feels that she should be protected from Bob. And so where do you draw that line? How do you manage that area? Sometimes you see it just that directly where we have proselytizing. Sometimes it's a more subtle thing. You might have a coworker who's constantly talking about abortion and talking about the actual process by which an abortion happens, and is sharing some pretty graphic aspects of some of the procedures. And the employee is sharing this in the hopes that this would persuade members of the employees to be more pro-life or something along those lines. The coworkers don't want to hear the graphic details. Maybe they don't believe that they're accurate. Maybe they do believe they're accurate, but they find the summary distasteful. And so they want to be insulated from it. So you can see in both categories, they want to be protected from what the religious person feels compelled to say. There have even been cases in which a person has felt a religious obligation to wear an item of clothing. The example I can think of is that the religious person wore a picture of a late-term or the after effects of a late-term abortion, and it was very graphic and difficult to see, disturbing to see. Anyway, he would wear this pin throughout his day, and people would encounter him and naturally look at his pin and be very upset about it. Whether they were pro-choice or pro-life, it was a disturbing image, and it would be distracting to the workplace. That would be an example. Could you say to this employee, well, no, you can't wear that, or you can wear it, but you have to wear something on top so that others aren't going to be offended or disturbed by seeing it. So all these are areas that you have to consider and work through when you happen to confront them. Are these common? Well, not common in the sense that every single workforce, every single workplace are going to have these issues, but they are likely to come up at some point during your career. And so when it does arise, I guess my first piece of advice would be to refresh yourself. The law may have evolved in this area since the last time you've looked at it. You may need some refreshment in terms of what the law actually requires and what the best practices are considered at this time. So I encourage you to do that. While it's important to address harassment concerns and religious accommodation concerns immediately, it's also important to give the right guidance. And so I would encourage you at that moment to reach out to an attorney who practices in that area to say, where is the current law? And maybe to give yourself 24 hours or so to kind of figure out. You may be able to talk to the proselytizing employee during that time and say, hey, Bob, can you put everything on hold for 24 hours? Can we just step away from this situation for 24 hours? Let me look into this area and get my bearings, and then we'll see kind of where the lay of the land is at that point. That could be one way of proceeding. Presumably, he doesn't have to raise these issues, every day of the employment relationship. On the other hand, if he says, no, I can't, my religious obligation is to do it every day, who knows when my coworkers might die in a car accident, and maybe they would die tonight on their way home, and I will have failed to offer them the opportunity to convert. I can't put it on hold. So under those circumstances, I'd probably just say, okay, one more day of it, then we'll figure out. Let me get going on figuring out what the limitations are currently. Let's see here. So how should one construct policies in this area? Well, your policies should be designed to protect those who do not wish to be approached about religious matters from those who attempt to proselytize. But one shouldn't say to the proselytizing person, Bob, you can't approach Mary. You can't ever have that first conversation with her. Because maybe Mary would be receptive. And assuming it wasn't during work time, it wasn't interfering with the progress of the work, an approach would be to hopefully work out an agreement with Bob, something like this. Bob, you can approach Mary once with this, and if she expressed an interest and wants more information, then of course outside of normal working hours you can certainly share that information with her. But if she says thank you but no thank you, then you cannot approach her again, or you have to wait at least 6 months or something before you approach her again. Work out something along those lines, because the person who is being proselytized is entitled to be free from religious harassment, just like the proselytizing or evangelizing employee is entitled to follow his or her religious dictates. We need to be sure that we protect employees who are engaging in religious practices that might be unpopular. For example, the Muslim employee who engages in a prayer or who wears atypical clothing in the working environment. This person might be teased or mocked or talked about in an unpleasant way. And so that person ought to be protected. And then finally, make sure that employees are given comparable opportunities to use workplace resources for religious practices. If you are giving space for the Muslim employees to engage in prayer activities, you need to make sure that you're providing a space for the Christian group who wants to do a Bible study, or the Jewish group who wants to have a place where they can have kosher snacks or something along those lines. It's a little bit more tricky, the differences between secular and religious. So let's say you allow the book club that has nothing to do with work to meet during lunch in a conference room. Would you then be required to allow the Bible study group to meet? My advice would be to let the Bible study group meet if you let the book group, because obviously Bible's a book, right? So that would be my advice. If an employer was very reluctant to do that for whatever reason, perhaps it was the Aryan Nation book club or something like that, then it would require, or I would encourage that employer to hire an attorney to look into particularly where the law is at that particular time. That could be a little bit of a risky move. You're probably not going to want to take and make the financial investment to investigate the law if it's something uncontroversial, such as the Rosary Club or the Muslim group who would like to pray during lunch or something like that. But when it is one that might be a source of controversy and you want to treat that group differently, that would be an opportunity where you would want to look at where the law is before you proceed. Let's consider a scenario. Bob is a Christian Scientist and his colleague is a born-again Christian. And Mary leaves a flyer for her church on Bob's desks, emails Bible verses to Bob, and invites him to attend church with her every Sunday. Mary asks Bob to stop. Bob asks Mary to stop, but Mary responds that her religion requires her to save lost souls. So Bob complains that this is harassment. Under these circumstances, Mary's behavior probably does cross the line into harassment because it has been severe and probably, maybe not severe, but certainly pervasive. And if she said things like, well, you know, you're going to hell unless you change religions or something like that, that could cross the line into severe. You can see part of it is just it's constant. Every week there's something. There's verses being emailed. That is really over the top. Another important part is that Bob has asked Mary to stop, but she hasn't stopped. And so both the frequency and the fact that Bob has asked her to stop. And so when you talk to Mary about this, saying, listen, once the person has indicated that they are not interested in hearing more about this, you need to stop. And that would be to permit Mary to continue to talk to these individuals after they've indicated they don't want to, would be an undue hardship because it's exposing the company to the possibility of a religious harassment claim by the people that Mary is attempting to convert. Public employers need to be especially careful about limiting religious speech. For one thing, there is the First Amendment, which of course has that free exercise clause, and so a government employer certainly cannot prefer one type of religion over another. But there's additional reasons why employers have to be concerned about that, and that is there's a particular guideline that was established several years ago when President Clinton was president that permits federal employees to engage in religious expression even if it's directed at fellow employees. Sometimes an issue comes up in this context wherein an employee has religious artifacts in their office. They may have a cross or a crucifix, maybe a Star of David, or some religious writings on their wall, maybe the Ten Commandments, maybe sayings of the prophet, or whatever the particular things might be. Some people maybe a Bible or a Quran is on display. Some employees might feel kind of uncomfortable going into what seems almost like a religious location, especially if this is their supervisor's office. They might, especially if they don't happen to be a member of that faith group, feel uncomfortable walking in and seeing these artifacts of the faith. Generally, if the employer allows employees to express their personality through the office, generally the employer should permit the employee to express his or her religious views. So if the employer permits, say, family pictures, posters on the wall, happy sayings, calendars, things like that, it would be difficult for an employer to legally prohibit a calendar with religious sayings on it. If the employer permits pictures on the wall, if that employer were to say, well, you can't have a Sacred Heart picture, that would be probably impermissible religious discrimination. On the other hand, if the employee puts up a picture of the after effects of a late-term abortion, a picture that would be fairly graphic and gruesome, and causing anyone who needs to go see this person to see this image, you could definitely treat that as a different situation, just like you wouldn't permit an employee to have a picture of, dismembered bodies or something like that outside of the context of abortion, because it would be disturbing to other people in the office. So you'd want to be consistent, but you could make some kind of generalization saying we're not going to have pictures that make people ill. We're not going to have pictures that frighten or disturb people. And that could be an area for a distinction that would allow you to prohibit certain types of pictures while allowing other types of pictures. But you probably should allow non-disturbing expressions of religion. Now, if it is a supervisor, you want to make sure that the supervisor understands that, especially in his or her role as a supervisor, the proselytizing needs to be really constrained. And this is something you'd have to work closely with this person if this person felt a religious obligation. Because a subordinate may feel pressure to convert because his or her supervisor is directing him to or her to. A subordinate may feel, well, if I don't convert, I'm going to get fired, I'm going to get bad performance appraisal, or I'm going to get extra work. If I do convert, things are going to be better for me. Maybe I ought to convert. Or maybe I don't want to convert, but I feel like it's a dangerous path for me to do. And so under those circumstances, be it the public employer scenario or the private employer scenario, you have to be especially careful as the HR professional. And I would encourage you to train the supervisor under those circumstances, but also to develop a relationship with the subordinate so the subordinates would feel comfortable to approach you if they feel like a line has been crossed. Okay, so let's move on to unions' duties with respect to religion. Again, this is not probably that likely to arise in your experiences in the HR/legal area, but I want to flag them just in the event that you might move to a different part of the country. So when an objection under Title VII is directed toward a union or a government or private sector employee, the employer itself, because of course it's a unionized facility, does have the obligation to reasonably accommodate an employee's religious conflict. So imagine for a second that a particular union, the leadership in the union is largely of a particular faith journey. We'll say that they're Lutherans, and they seem to not be willing to take seriously the complaints of people who are members of other faith journeys. They seem to prefer people from their congregation, and when other people are making objections or to practices or policies, they don't seem to be heard. Under those situations, the employer does have the obligation to make sure that with respect to the workplace, the employee is not being disadvantaged because of the religion. So let's say that the employer has a job bid process, and so when an employee is seeking maybe a promotional opportunity, the employee goes to the job board and finds the opportunities are available and then bids for it. And the process established by the collective bargaining agreement requires that the employee meet the minimum qualifications for the job, perhaps having a certain number of years of experience, having certain training certifications, currently being rated acceptable in certain areas of performance. And amongst that population, perhaps the most senior member is the one who will be selected. Well, let's say that Bob is the one who meets all the qualifications and is the most senior. But Bob isn't a Lutheran. Bob is a Hindu. And so the union is complaining about the fact that Bob is not the person they want. Teresa is this person who has the second most seniority, and Teresa is a Lutheran. And so the union is pressing for Teresa to become the head person. And maybe Teresa has higher performance appraisals or more certifications that would be relevant to the job. So there is an argument that Teresa would be the better candidate, but according to the terms of the collective bargaining agreement, it ought to go to Bob. Well, under those circumstances, the employer needs to follow the terms of the contract despite what the union might be saying. The employer is going to need to put Bob in that position. The employer can't say, wait a second, union wants me to put Teresa in, so I'm going to do that. No, if the union is violating Title VII, is discriminating against people because of their religion, the employer certainly shouldn't enable that in any way, shape, or form. Now, obviously, the employer can't get involved in the internal affairs of the union. If the union isn't applying the rules appropriately within its own organization, that's kind of on the union. It's not going to be on the employer. But when it affects decisions that an employer makes, then the employer does need to be sure that it's following the terms of the collective bargaining agreement and is also complying with Title VII. We've already talked about this, but a little refresher. Title VII does prohibit an employer from discharging an employee for refusing to join the union because of his or her religious beliefs. Again, not really an issue in Texas because we are a right-to-work state, and so therefore it would be unlawful for an employer to fire an employee who refuses to join the union, even if religion weren't an issue. But if you were to move to a union security state or to a non-right-to-work state, this can become an issue. And let's talk finally about religious organizations. So we have two categories here that we're going to focus on. The first is the BFOQ, the Bona fide occupational qualification. We talked about how this can exist in the areas of gender, For example, there may be certain jobs that only women can do or only men can do. Oftentimes sometimes it's because of a physical aspect of the physiology of men and women. For example, only women can give birth, only men can impregnate, only women can lactate. Or it could be because of some identification. For example, if I am a movie maker or a theater company and I want to stage a play, maybe it's a story about Helen Keller. Well, I might have a very talented male actor who auditions for Helen Keller, but he looks male, and so therefore that would be not what our audience would be expecting. Our audience would be expecting Helen Keller to be a woman, and so it would be reasonable to be a BFOQ under the situation for the theater or the movie maker to say, no, we're really just going to be considering women for this particular role. So those would be examples of BFOQs for the area of gender. For the area of religion, BFOQs can come up in a couple of different ways. One way, and this is again an example that I'm sure I've used before, is a circumstance under which the person has to be a member of the religion in order to accomplish a particular task. So imagine that you are a hot dog maker and you want to make kosher hot dogs. You feel like that is part of your marketing plan. You feel like this community is underserved in your particular demographic, and you feel like this is an opportunity for you to move in and make some good profit. So it's a business decision for you. You research, well, what do I need to do in order to be certified as kosher? So you research this area and you discover that there are lots of different processes that have to be in place in order for these hot dogs to be coded as kosher. And you learn that even if you follow all of the rules to the letter, you still are going to need, you're still not going to be able to call your items kosher. You will actually need to have a rabbi who will certify that the process has been followed. Now, it's certainly the case that a Lutheran or a Buddhist or an atheist would be as able to know the process and to make sure that it's being followed consistently as someone of the Jewish faith. I mean, it's just facts. You could learn it no matter what your particular religious beliefs are. But a devout Jewish person would insist upon having the credentials of a rabbi to say, yes, everything was followed, that there is a religious component to it in addition to the actual factual requirements of it. And obviously, to be a rabbi, one has to be of the Jewish faith. And so a BFOQ under those situations would be that person that would have to be Jewish. Now, I'm not an expert in kosher rules, but I believe that it would be fine, though, for most of the workers to not be Jewish. They could be of whatever religion, or they could be atheists, as long as they're following the procedures and the Jewish rabbi is there to confirm that those procedures are being followed. So an employer wouldn't be able to say, well, I can only hire Jewish people for this whole hot dog making process. No, the employer would only be able to identify the number of positions that have to be held by a Jewish person based upon whatever that standard is for establishing kosherness. So that's one BFOQ, but probably that's not tremendously common. There's not a lot of jobs out there that really require a person be of a particular religion. We see most BFOQs in the area of religious entities that want to make sure that the people that they are employing have a similar outlook on particular issues. Imagine for a second a Catholic high school, and that Catholic high school wants to hire a teacher to teach Catholic theology, the catechism, to its high school students. Now, somebody who isn't Catholic can be as knowledgeable about Catholic theology as a Catholic person, obviously. And so you could say, well, if you've identified a Muslim person who's very, very conversant in Catholicism, maybe that the Muslim person once was a devout Catholic. Or perhaps this person has just had an intellectual interest in the Catholic catechism. So this person would be fully qualified to teach it. But the students probably would know this person is teaching us this, but this person doesn't actually believe this. And so that might cause those students to be less likely to internalize that information. They accept the information intellectually so they can get a good grade on the test, but they aren't actually putting this into their own life and putting it part of their value system. And so that Catholic high school would be perfectly within its rights to have a BFOQ that whoever was going to teach the religion course, the catechism course, also be a Catholic, and not just a Catholic, they could even say be a faithful Catholic, somebody who attends religious services every week, somebody who believes the catechism. And so that would be a BFOQ with respect to religion. Okay, so Title VII includes a religious organization exemption. This provision of Title VII exempts from its coverage those hiring decisions made by religious employers on the basis of religion. So again, this is that similar to that BFOQ that we were talking about before. This is the religious organization exemption. Religious organizations can limit employment to or have a preference for persons sharing the same faith. Now, this is an important point to make. It could be in a particular geographical area that the employer, we'll say again, we'll give the example of a Catholic high school. The employer prefers Catholics to be its employees, and let's say for a particular job it receives 5 applicants. 3 of the applicants are Catholics, 2 are non-Catholics. The 3 Catholics who apply do not have degrees in, let's say it's chemistry teachers, do not have degrees in any hard science, haven't taught previously at the high school level, and do not have a very impressive resume. One of the individuals who isn't Catholic has a PhD in chemistry, has extensive teaching experience at both the high school level and the college level, and this person is a devout Lutheran. So this is someone who shares many of the same beliefs that the Catholic community would share. It would be fine for the Catholic high school to say, we're going to hire the Lutheran PhD. We give a preference to Catholics, but it's not a deal breaker that a person isn't Catholic. We're not going to hire somebody that's clearly less qualified. So the preference doesn't have to be absolute. It can be. I mean, certainly an organization can say, we're not even considering non-Catholics for this particular role. Or it can be, we're giving a significant amount of weight to the person being Catholic, or perhaps being Christian. It may be a broader category than just that particular denomination. So that is the religious organization exemption. We have another exception we'll talk about in a few seconds. That's the ministerial exception. It's important when we're talking about this that we make an exception between the ministerial exemption and the religious organization exemption. If you're going to get confused about this, my guess is you're going to conflate these two, get these two confused. So I encourage you when you review this material to identify and kind of separate them. So let me be clear here. The religious organization exemption has to do strictly with whether the person is a member of this religious faith group or not. That's the only preference that the religious organization has. So let's go back to my example of the high school that wants to hire a chemistry teacher. So now let's pretend this time that all 5 of the candidates are Catholics, or maybe none of them are Catholics, but in any event, the whole religion thing is no longer in play in this particular position. And it happens that one of the persons who is applying, or 4 of the people who are applying, are men, and 1 is a woman. Well, the principal of the school just really feels that women, and the woman who's applying has a young child at home, a preschool age child. Well, the principal feels that really women who have preschool age children ought to be at home caring for their children, and so he discounts her candidacy and hires from the remaining 4. Well, she's the one who had the PhD in chemistry. She's the one who has extensive teaching at the high school and college level. So on paper, she seems to be the most qualified of the candidates. Under those circumstances, the religious organization, the high school, has violated Title VII by discriminating based upon gender plus actually, by saying we're not going to hire women who also have a preschool age child. The religious organization exemption does not provide protection for discrimination based upon anything other than the religion. It's limited to those categories. So just want to make that clear, that a religious organization can be subject to Title VII issues, or Americans with Disabilities Act issues, or Age Discrimination Employment Act issues. The only thing they're protected from is that they cannot be sued successfully for religious discrimination. And then that's the difference that we'll talk about when we get to the ministerial exception. So courts have created, this is again a court-driven exception. You won't find this actually listed in Title VII, but this is the ministerial exception. And when we use the term ministerial here, we're talking about, ministerial kind of has 2 meanings, as you probably know, in the English language. One is the idea of a religious leader, a minister, a rabbi, a priest, an imam. That idea. It also has a different meaning in a different context, a ministerial act. We're not talking about that meaning. We're talking about the minister idea, the reverend, the vicar, the priest, that type of idea. So we're really restricting our audience here to people who are teaching or engaging sacramentally in that role as minister. A minister isn't the chemistry teacher. I mean, in a Catholic high school, I'm guessing that there's probably a crucifix, and it may well be that the textbooks that are used in the chemistry class are Catholic high school specific, so there are mentions of religious aspects to chemistry. And there may be, in the chemistry class, maybe at the beginning of class, there's a prayer set or something like that. But let's face it, I mean, chemistry is chemistry, and chemistry is the same. The periodic table is the same, whether you're a Lutheran or a Muslim or an atheist or an agnostic. It's the same thing. And so that the person who is the chemistry teacher is not acting as a minister. So why did the courts create this exception? Well, it really goes back to the idea that the government ought not be telling religious entities how they ought to run their own business. In some sense, when we're looking at laws like Title VII, we're having the federal government tell employers how to run their business to some extent. And I mean, that's fine. The commerce power, the Commerce Clause in the Constitution, the courts have ruled, do give Congress the ability to do this. But of course, there is also the First Amendment. And so when Congress is telling private employers you can't discriminate on these bases, that's fine. There's no First Amendment issues there. But when the Congress is telling religious entities, hey, you know what, we're going to tell you how you need to hire your ministers, that has really, really important First Amendment issues. Imagine for a second that there is a religious group who believe that only men can be, we'll say it's a Jewish synagogue. They believe that only men can become rabbis. They believe that that is part of their theology. And a woman rabbi applies for the job of leading this particular congregation. And because other Jewish groups do permit women to be rabbis, she has a great deal of experience. She went to a prestigious rabbinical school. She has many years of experience being a rabbi. She's been very successful. She has very significant ministerial skills in this area. The other candidates for this rabbi position have much less impressive credentials, but they're male. If we didn't have this ministerial exception and the congregation selects the male rabbi who is less qualified, then that female rabbi could sue and saying, hey, I'm a victim of sex discrimination. I was denied the position solely because of my gender. And I mean, she would be right, but this particular congregation feels that a rabbi needs to be a man. So the reason for the discrimination has a theological basis. You and I might think that's a good theology or a bad theology, but we're not, the federal government isn't supposed to be expressing an opinion or forcing a particular theology upon a religious group. And so that is the background of this ministerial exception. So what is the scope of this? Well, let's first of all review. It prevents the application of any of Title VII's provisions for a religious organization for employees who perform essentially religious functions. And so here are examples of employees who fit in this category. They're involved in church governance, deciding the spiritual path of that particular church, whether the church is going to get involved in this ministry activity or that ministry activity, whether they're going to build a new facility or focus on this particular thing or focus on that particular thing. Also, another category would be supervising a religious order. Perhaps it's the abbot or the leader of a seminary or something along those lines. That would be an example of somebody who has essentially a religious function. And then finally, anyone who is involved in conducting religious rituals, worship, or instruction. So going back to my high school example, that individual whose job was to teach the Catholic catechism to the high school students, he or she would be involved in instruction. And so under those circumstances, the employer could say, yes, we prefer men for this role, or we prefer people of this particular race for this role, or we prefer people of this particular national origin for this role, and that would be permitted. But when it comes time for the chemistry teacher, because the chemistry teacher isn't conducting religious rituals, isn't in conducting worship, isn't conducting instruction, and we're assuming that we know that the job duties of the chemistry instructor and that these are not part of his or her job duties, then the ministerial exception isn't going to apply. Yes, we still have the religious organization exemption, which basically becomes a BFOQ, which allowing the employer to have a BFOQ for religion, but it doesn't allow the employer to discriminate against the chemistry instructor for, based upon sex or national origin or race or something along those lines. So with the ministerial exception, discrimination on other protected class grounds cannot be contested. Apologize there. Cannot be contested because the ministerial positions with spiritual functions are involved. This exemption now includes not only religious activities, but also secular endeavors such as schools, hospitals, and shops, at least when they are nonprofit organizations. And so again, that school that is run by the Catholic Church, that hospital that is run by the Lutherans, that shop that is inside the Jewish synagogue that sells, maybe religious artifacts for members of that congregation. All of those entities can potentially use this exemption. So maybe the head of the school, because now he is supervising that religious organization, or the hospital head who is conducting that, or maybe the chaplain in that Lutheran hospital. The ministerial exception is going to fall in and apply to that. Now, of course, the hospital employs a cardiologist. Is that going to apply to that cardiologist? That Lutheran hospital can say, wait a second, we prefer cardiologist Bob, who isn't nearly as skilled, but he's a Lutheran, over cardiologist Aisha, because Aisha is a woman and we just don't think women ought to be cardiologists. No, that would not be appropriate, because a cardiologist's primary function isn't religious. So it doesn't mean that everyone in that particular organization is going to fit into the ministerial exception. It'll probably be a relatively small number. Those that do explicitly religious things, and those who manage the overall entity. So at this time, we have completed all of our topics. Today we've covered religious proselytizing and the topic of harassment. We discussed union duties with respect to religion, and we discussed religious organizations. Before we end, though, I do want to go back and talk just for a second about the harassment area. I didn't dwell upon it in this presentation, but because we've covered this in the sexual harassment topic and also some other topics, but I want to just take a second just to remind you that all of the harassment training you develop as an HR professional or as a legal professional supporting an entity, an employer, needs to cover religious harassment just like it covers all the other categories of harassment. Because all of the things we've talked about harassment before in other areas applies to religious harassment. So the Felliger-Allerth defense is available to the employers if the employer can demonstrate that it has provided that religious harassment training, has provided a mechanism for the acceptance of complaints in this area, and conscientiously and quickly and reasonably investigates those matters and resolves those issues, perhaps through discipline, perhaps through other mechanisms. So you want to be able to take advantage of the Felliger-Allerth affirmative defense. You want to make sure you have all those pieces in place for religious harassment, just like you do with sexual harassment, race harassment, national origin harassment, all the other categories of harassment. So just keep that in mind when you're developing your policies. After notice of religious conflict, immediately try to find ways to manage the matter. This can be difficult, again, if you have coworkers who are tense about these areas, and certainly religion is a topic that is important to many workers, and even those that it's not important to, they may very much prefer not to have that as part of the workforce experience. And so it does require a deft and diplomatic hand to maneuver through those situations. Ask the employee with the conflict for suggestions on how to resolve the conflict. Just because you're asking doesn't mean you're going to agree to them if you are the HR professional, but that's a good first step. For one thing, it's good for the employee. The employee is going to feel like he or she's being heard. For another thing, the employee may have some great ideas, things that you might not even be aware of. For the third reason is that it's good to document that in the event that you're not able to resolve the issue in a way that the employee prefers, and that there is some kind of lawsuit. The fact that you ask these things means that the jury's going to hear that, and that's going to be a good fact for your employer under those circumstances. Ask but do not require other employees to assist. I'm mentioning this when we're talking about a reasonable accommodation. For example, let's say that Bob can't work on Sundays because of his religion, and so the plan is to invite other workers to swap schedules with Bob. And so you want to provide a situation that encourages employees to seriously consider that option. But it's probably best not to require employees to do that switch. If an employer wants to require, that's certainly something that should be explored in more detail to make sure that that is not going to raise a religious harassment type of claim or something along those lines. And so, but when you ask, you ought to do it in the mode of, listen, we really want to accommodate this person. It shouldn't be presented like, gee, we have to ask, but we know none of you want to do this, because who would want to do this? But we've asked. No, that's not the way to do it either. You want to do it in a way that encourages individuals to seriously consider it, even if you are not requiring them. So we're done with our religious discrimination and harassment presentation. As always, if you have questions about the materials, please feel free to send me an email. My email is cgroover@collin.edu, or better yet, come by. I'd be glad to talk with you in more detail about this topic. I didn't mention this before, but this was the topic religious discrimination that I used for my third-year paper in law school. So it's rather near and dear to my heart. It's something I've thought a lot about, and so I'd be delighted to talk with you in more details about exactly how this area of the law kind of plays out in the real world and how to address those issues. Certainly it was something that came up fairly routinely in my practice, and certainly I think that it's, if anything, more likely to come up now than it has in the past because our workforce is increasingly diverse in these areas. So I thank you for your attention, and I hope you have a wonderful day. Take care.